Okay, welcome everybody. We're here today to talk about the rights regarding rent and utilities for domestic violence survivors under California law. So the purpose of today's presentation is for you to learn how California law can help you kick your abuser out of your rental unit while still being able to afford living there. So why does this matter? If you share a rental unit with your abuser and you are both on the lease, you're probably concerned that if you kick them out, then you are going to be responsible for the total rent payment. As we all know, rent is very, very expensive right now in California. This would obviously be very worrisome for most people. Handling their entire rent payment alone is very difficult. So the good news is that California law offers some protections for you if you do find yourself in this situation. So you don't need to worry about being responsible for the entire rent payment. And we are going to talk about that moving forward. So the first thing I want to talk about is restraining orders. So a lot of you probably know what a restraining order is already, but just in case you don't, it's a court order that restrains another person from having contact with you, and that includes electronic contact, that includes communication with you, third-party communication. They can't have a third person contact you unless it's an attorney. And then, of course, it also involves physical contact and usually includes a provision that they need to stay a certain distance away from you. Let's say, for example, 100 yards. And if they get closer than that, or if they contact you by phone, email, social media, or have a friend try to talk to you, all of those would be violations of the restraining order and they could be arrested. So it's a very powerful tool if you find yourself in this situation that you can use to protect yourself. As far as how to get a restraining order, that's something that if it's a domestic violence situation is normally addressed in most of the time in family court. If you would like to get a restraining order, you can get to family court. Most of the family courts have like a family court services department where they can help you fill out the forms, know which forms to file, and they can counsel you on the process of actually successfully getting a restraining order. So that's a good option. Of course, if you are financially able, it can also be very helpful to retain a private attorney, but that's not always necessary or possible. So just keep in mind that resource of family court services is available. Another thing you can ask for is a kick-out order. When you file a restraining order, there is a section on the request to ask the court to kick this person out of the home if you and the other person are residing together. So if you find yourself in this situation where the person you're residing with is abusing you, definitely make sure that if you're seeking a restraining order, you ask the court for a kick-out order. And there are some other orders too that we're going to talk about in a minute that will be very helpful for the situation as well. So it's very important to understand that if you do get a kick-out order or even just a restraining order and the other person's on the lease and they're not able to come back home, there is this California Civil Code section 1941.6, which says that the person who is excluded from the unit, so the abusive person who the restraining order is against, remains liable for all of the rent along with all other tenants. So even though they're not living there, they're still on the hook, and not just for the portion of rent they were paying before they got kicked out. They're actually on the hook for the entire amount of the rent, just like anybody else who's on the lease. So keep that in mind. If you find yourself in this situation, if you don't pay, the landlord can go after that person just as much as they can go after you. Another really good thing about this law is that the landlord is no longer liable to the excluded person for any of the provisions of the lease. So the excluded person is still on the hook for everything they agreed to in the lease, whether that's paying rent, paying the water bill, or paying for parking all of those things that they agree to, they are still on the hook. But all of the things that the landlord agreed to as part of the contract, such as, providing that person who signed a place to live, the abusive person who's been excluded from the home, the landlord is not liable for that to them for that anymore. So that's really good because it doesn't put your landlord in an awkward situation where they're in the middle of it. You are protected by the law, and so is the landlord for helping you, enforce that and not being liable to the excluded person and being required to give them a place to live. The landlord is also required to change the locks upon request, and I'll talk more about that later on in the presentation. So as part of a restraining order, you can also ask the court for a specific order requiring that the abuser pay the rent. So the difference between this and what we already talked about is that this is a specific order. You could actually ask the court for specific order that the abuser pays all of the rent, not just equally liable for the rent with the other roommates or the other tenants, but you could ask the court that for an order that the abuser is liable to pay either all of the rent or a specific amount of the rent every month. So this can be a very useful law as well. It comes from Family Code section 6324, which allows the court to make an order determining the payment of any liens or encumbrances during the time the order is in effect. So that means that you're not just limited to asking the court to order the abuser to pay rent. You could use this for other things as well, whether that's utility bills, other types of bills that you may have incurred or debts that you may have incurred as a couple, car payment, things like that. So this is also a very useful law. You want to keep that in mind. I would say that if you are seeking a restraining order against a partner, even if you weren't tenants, if you had any shared financial type of situation, you certainly would want to make requests under this situation. And it would help you probably to point out the need for doing that, whether that's, not making these orders would just be unduly burdensome on you. Maybe you wouldn't be able to afford the rent, you wouldn't be able to afford your car, things like that. I think our arguments you would want to make to the judge to make it more likely that they would grant this order. Okay, so a really strong right and a really valuable law that we have in California that would protect people that are survivors of domestic violence is Civil Code section 1946.7. This law allows you to terminate your lease if you've been the victim of domestic violence, sexual assault, stalking, human trafficking, elder abuse, crime that caused serious injury or death, a crime involving a firearm, or a crime that involved the use of force or the threat of use of force. So if you are in a situation where you want to use this law to terminate your lease, this is how you do it. One, you need to give your landlord notice in writing, and that notice needs to be accompanied by either a restraining order, an emergency protective order, or a criminal protective order protecting the tenant, a household member, or immediate family member. That's one of the options. Or you can provide with your written notice that you're terminating the lease, a police report stating that you or a household member or immediate family member filed a police report alleging they were the victim of one of the aforementioned crimes that we talked about on the last slide. You can really also use any other form of documentation that reasonably verifies the occurrence of one of the aforementioned crimes, or documentation from a third party based on the information received by the third party while acting in their professional capacity that the tenant, household member, or immediate family member is seeking assistance for physical or mental injury resulting from one of the aforementioned crimes. So That could be domestic violence or sexual assault counselor, human trafficking caseworker, victim of violent crime advocate, things of that nature. I think one of the important things to point out about this statute too is that it doesn't necessarily require that these things happen to you. If it happened to your family member, so it happened to a brother or sister, your mother, your father, or even a child. Sometimes people find themselves in situations where their children are in an abusive relationship. You can still use this law to protect yourself. It's just important that you have the proper documentation, that you notify your landlord in writing. And this is really an absolute right. Your landlord can't deny you this if you meet the requirements of this section. So some of the other requirements to meet if you would like to terminate your lease under this section, the notice to terminate your lease, you must give it within 180 days of the court order, police report, or crime occurrence. So you don't want to sit on this. If you would like to use this statute, if you feel like you need to use a statute to get out of your lease for whatever reason, whether you don't feel safe there, whether the cost is just too much, different things like that, you just don't want to sit on the situation. Make sure you do it as soon as you have the documentation, because if you wait more than 180 days, you're going to lose protection of this law and you won't be able to terminate the lease under it. So make sure you try to move as quickly as you can to take advantage of this law. Another great thing about the law, about 1946.7, is that once you actually give notice to your landlord, they can only hold you liable for 14 more days worth of rent. So what does that mean? That means if you give notice today on April 19th, that means 2 weeks. The landlord can only charge you 2 weeks more rent or 14 more days rent. So you're looking at about May 3rd. You're no longer liable for any rent under the lease. And more than likely, you might need that 2 weeks anyways to get a lot of your stuff out. So it's a strong provision. It offers a lot of protection to tenants who find themselves in this situation. And then also very important, I know this comes up a lot in just our general practice, is landlords improperly deducting from people's security deposits. So the law specifically states that if you decide to terminate your lease under Civil Code Section 1946.7, your landlord cannot keep your security deposit solely because you're terminating the lease under this section. However, aside from that, normal security deposit rules apply. So what does that mean? That means that if you still have 6 months left on your lease, your landlord cannot keep your security deposit saying that you still owe him 6 months of rent, because you're terminating it under Civil Code Section 1946, which releases you from all the future obligations under the lease. However, the fact that normal security deposit rules apply means you can't trash the place, or if you already had, if there was different damages, there was holes in the wall, or different types of damages to the home, or if you don't clean it when you move out, the landlord can still deduct from the security deposit for those reasons. So just keep that in mind. You want to clean the place and fix anything you can before you move out if you're hoping to get your entire security deposit back, but they can't use it towards future rent. So still a pretty strong protection there. So utilities, there are also some strong protections for your utilities bills. So you can, under PG&E's rules, each adult in the home is equally liable for the utility bills if you're living in the home at the time that the costs were incurred. So if you're the one leaving the home, you want to make sure that you try to get your name off the account as soon as possible. We'll talk more about this, but you want to call the company right away and let them know, look, I'm not living there anymore. because you have the right, as we talked about here in California, to dispute your utility debt. And if you can prove to the company that you weren't living at the home at the time the charges were incurred, you have the right to dispute that. So you want to put the company on notice, certainly right away, that you're not living there anymore, and make sure you have good documentation of that. The fact that you're not living there, documentation maybe of your new residence, and keep a record of that, put them on notice. And if they're not working with you, you can see here below, you can file a complaint disputing utility debt by contacting the California Public Utilities Commission, the Consumer Affairs Branch. Also, a helpful provision in the Public Utilities Code, section 394.4 of the Public Utilities Code. It requires utility providers to keep your information confidential unless you consent to its release in writing. So if you're trying to keep that, your new address, your new contact information confidential, which is often the case when you're a survivor of domestic violence, this law offers you some strong protection. You can rest assured that the public utility will not be releasing your information to the abuser, and if they do, they would be in big trouble for that. There would be some pretty strong liability there. And then another suggestion I have is just talk to your provider. Also, it can be really hard sometimes if you were on the prior account, even you have these rights under the rules. If there's a prior debt and your name was on there and it's not paid, it can be hard to open a new account. The companies are not that easy to work with sometimes. So, but talk to them. They're not mandated by law to do these things, but oftentimes some providers will work with you. They may be willing to waive deposits for some survivors of domestic violence, or even if you do have to pay a past due balance, they may be willing to arrange a more flexible payment scheme. So feel free to address that with them. And then there's one other thing I wanted to talk about. I think I may have skipped a slide, but I mentioned it briefly, and I told you I would talk about it later, which is that your landlord is required to change the locks. So in the event that you are the victim of or survivor, you find yourself experiencing domestic violence, and you get a restraining order against your abuser, and if they were a tenant, your landlord is required to change the locks within 24 hours. And that's also a really strong protection. Obviously, you would want to take advantage of in that situation. And let's say you can't get a hold of your landlord, they're just not cooperating. After 24 hours have passed, and you provided them notice and you provided them a copy of the court order, which are both required. If they haven't changed the lock, you have the right to change the locks yourself. Just needs to be a lock of similar quality as the prior lock. And then you need to notify the landlord that you changed it yourself, and then set up a way, any type of reasonable method for you to get the new key to your landlord. But that is another right you have under the law to keep yourself safe in one of these situations. So that concludes the presentation today. Again, we apologize for the technical difficulties that we experienced in the middle, but we got through it. I see there are a lot of comments in the Q&A, so I'm going to go through. I'm not sure if anyone has answered these, so I'll do my best to answer them now. And if I don't answer your question, or if you have further questions, I think I said this at the beginning, but feel free to reach out to us at HERA, and we will do what we can to get your questions answered. So, okay, one is please email me the presentation. We can definitely do that.
All the way the
I'm
emails,
sorry.
and all the way at the bottom there's the questions Q&A at the bottom, and they have not been answered yet.
Okay, thank you. Okay. I had to get assistance from a program to pay for my locks to be changed. It took months. I've asked about the front door, the entry to the building, but no response back. Okay. Well, actually, we were just talking about that. So technically your landlord is responsible to change the locks. The law actually doesn't talk about who is responsible for the cost of that. However, I think you have a good argument that the landlord should reimburse you. I think if you had this other program, if they paid for it, they may want to seek reimbursement from your program or from your landlord. As far as the front door, from your question, I'm gathering that it's like a separate entrance. There's the entrance to your home, and then there's also like a front entry to the building. Again, a law doesn't talk about that, but I think you have a really strong argument to get your landlord to change that. I mean, if I was the landlord, I would want to change that because don't want the abuser coming in the building. That could, even if they can't get in a specific unit, obviously can create a dangerous position. So I don't want to identify anyone by name, but if you would like to have that issue addressed with your landlord, you can reach out to HERA and do an intake with us, and we can certainly help you address that issue with your landlord and advocate on your behalf to make sure, you know, we get you into a position where you're a lot safer, and, you know, also the financial side is taken care of. Okay, we have a question from Max, who works at HERA, which is why I identified him by name. Can you ask the landlord to reimburse you if you change the locks yourself? I think I just addressed that. We don't have a straightforward answer, but we can certainly, you know, again, we can help you get there. And then also from Mava Brown, the director of HERA, you have to give keys, the new keys to the landlord. I think I did answer that. I'm guessing maybe you asked that before I said it, but yes, you do. You have 24 hours to let them know you changed the lock and to work out a reasonable method for getting new keys to the landlord. Can your landlord charge you for changing the locks as the lease states? I think everyone's kind of going to the same place with this question. I don't have a direct answer or a definite answer for you. But again, we could do the research. If you find yourself in that situation, you can call HERA. We can definitely research it. And we can definitely try to make sure that, you know, you're not required to pay for it. We'll do our best to do that. So reach out to us if you find yourself in that situation, and we can work with you on a one-on-one basis. Okay.
And do you have contact information you can provide on your screen right now?
I will do that. Yes. I think I can do that. So I'll do that at the end after I answer the questions. And then, so one of the tenants create noise, advise property manager, and was told to call the police. Landlord needs to call the tenant's attention regarding the noise. Am I right? Police matters. Yes, this seems like a little bit of a different question, but definitely a tenant's right question. I don't know that it's necessarily relevant to domestic violence, but I'll go ahead and answer it as you have the right to quiet use and enjoyment of your unit, which basically means, you know, you have the right to enjoy your rental unit free of disturbances from the landlord or the other tenants of the same landlord. If that right is being interfered with, you do need to address your landlord. You should address that with him or her. And if you want help with that, again, reach out to HERA. That's something we help people with on a regular basis. And, you know, we can help you contact your landlord, or we can do that for you to address that issue. So again, I'll be giving the contact information at the end of the presentation, so you guys can reach out to us. How about the damages due to domestic violence? So if you're saying, I'm not exactly sure what this is referring to, but if you're talking about the security deposit part, which maybe you are, again, if that person's on the lease, you know, they're just as responsible for the damages as you are. At that point, it would probably, the law doesn't explicitly say that that's something a landlord needs to consider, but I think if you explain it to your landlord, they hopefully would hold the other person liable for that. If not, I think you would have a civil claim against that person if they caused the damages, and maybe something you could take up either just through a demand letter or through small claims court. Or again, it's a very specific situation. You can again contact us and ask for an intake, and we can help you address that. Can the landlord only hold you liable for 14 days worth of rent, even if you stay in the home? No. If you stay in the home, you're liable for rent for the time that you're there. The idea is you're giving notice, you're terminating the lease, so you're going to want to get out right away. I mean, I think that law kind of implies or infers that you want to leave right away. This is a dangerous situation. So the idea, I think, the thought process behind it is that you don't want to stay for more than 14 days. But yeah, if you stay in the home, you're still going to be liable for rent for the days that you stay there. Can the landlord still apply lease penalties, like pay every month? No, they cannot in this situation. They can't apply those penalties. You're released from all, after the 14 days, you're released from all future obligations under the lease. What if you don't want to terminate your lease because then you'll become homeless? How do you pay the rent? Can a tenant be evicted for non-payment of rent? Yes. So if you don't want to terminate the lease, you're going to want to go to family court like we talked about. Seek a restraining order, ask the judge for an order under the family code that the abuser is liable for the rent if you can't pay the rent. Also, I mean, keep in mind that even if the judge doesn't grant that order, the abuser is just as liable for rent as you are. So hopefully that answers your question. But yes, I think in the long run, if you don't pay rent and you're still living there and nobody's paying the rent, you're probably going to end up in a situation where the landlord would be trying to evict you. However, there's also other organizations, if you find yourself in that situation, that you could reach out to, such as Catholic Charities, and there's other resources available to you that would probably help you bridge the gap in rent. So the questions about that, reach out to us as well. And it looks like all the other questions were mostly just people saying they couldn't hear me in the beginning. So I think that's most of the questions. If you do want to reach out to us, you can reach out to me by email or by phone. My email is just my first initial. I'll put it in the chat and the Q&A if I can, and feel free to reach out to me, and I'll either help you directly if it's something where maybe somebody else at HERA is better positioned to help you. We'll put you in contact with them. Here's my email, my phone number. Okay, so I answered that into the chat. Let me know if see that. And the questions and answers. Looks like 2 participants have raised their hand.
Yeah, it looks like what you sent did not show up. The chat is disabled, so they're unable to view the chat.
Okay.
If you want to go ahead and just share it and say it out loud, and also if once I send out the PowerPoints, I could also include Daniel Vespe's contact information there as well.
All right, thank you. That's a great idea. But for everybody here who's here right now, my phone number, reach out to me at 619-693-8383. Again, that's 619-693-8383. Or feel free to email me. It's my first initial, D for Daniel, my last name, Vespi, VESPI, at HERACA.org. So that's HERACA for California, and then .org. So hopefully, you guys will be reaching out if you have any more questions or you think you could use a little more assistance on these issues. And then again, I think Alejandra is going to be sending out these slides too, so she'll include my contact information in that email as well. We thank you all for attending today. Hopefully it was helpful. Hopefully you learned a lot. a lot of information that will be useful for you. And then, yeah, we hope you also reach out to us in the future. We wish you guys the best of luck with whatever situation you find yourself in. And, we're also here to help in other situations regarding debt and credit counseling, home preservation, estate planning. So if you have any of these things, feel free to reach out to HERA. We're going to go ahead and end the presentation now, but thank you again, and hopefully this was helpful.